Today we're diving into a comprehensive guide through the probate process in Tennessee. Hi, I'm Scott Hines, a real estate broker and certified probate real estate advisor in Tennessee. Let's demystify the probate process and explore what it entails for anyone navigating the complexities of settling an estate. Probate, while debatable in its necessity for estate settlement, has become commonplace in Tennessee. Depending on the estate's size and complexity, banks often require official probate court approval before transferring or providing access to assets. The probate process can be confusing. Adding to the challenge, that's why we are here to provide a breakdown of the Tennessee probate process and guide you through what to expect. When an individual passes away, they lose legal possession of their property and assets. They also relinquish their debts. However, these assets and debts don't simply vanish. A complex estate may necessitate the probate process to validate the will, ensuring a smooth transfer of assets to appointed beneficiaries. Additionally, the probate court authorizes the appointed executor or administrator to handle various financial matters, including working with banks, insurance companies, and addressing tax issues. Probate is typically required if the deceased had debt, owned property, or assets that can't be directly passed to a spouse or partner, or possessed bank accounts, investments, or life insurance policies without named beneficiaries. These institutions may require probate involvement to avoid potential legal issues if the will is contested later. If the estate includes probate real estate not intended for a surviving spouse or partner, probate is also likely. Initiating the probate process involves applying for probate in the appropriate county. Probate must be filed in the county where the deceased person was living at the time of their death. Keep in mind that Tennessee probate process involves cost, including filing fees and other expenses that can vary based on the estate's size. One of the first steps in the probate process is authenticating the will, if there is one. The decedent's will is a critical document required for the entire probate process. The will must be submitted to the probate court for official approval. This step also addresses potential will contests or objections to the nominated executor. While this step is usually straightforward, complications can arise, requiring the involvement of a probate attorney. Authenticating the will also involves appointing the executor named in the will. This individual is tasked with executing the wishes outlined in the will. If there is no will, or if the will doesn't name an executor, a legal process will appoint an administrator to handle estate matter. This might be a close relative or a personal friend. Keep in mind that this process can involve additional probate court costs. To apply for probate, the executor or administrator must provide a comprehensive list of assets from the estate. This list, along with estimated values, is vital for calculating the estate's total value. Assets can include bank accounts, investments, insurance policies, safe deposit boxes, valuable items like artwork and jewelry, as well as property deeds. Some assets may require appraisals to determine their value. If the deceased had debts, the executor or administrator must notify a creditor. In most cases, debts are settled using funds from the estate. This step is crucial to ensure the estate's liabilities are addressed. Next, the executor or administrator is responsible for filing any outstanding tax returns for the deceased. They may also need to submit an estate income tax return. Additionally, if applicable, probate taxes must be paid. Once all the fees and debts are settled, the executor or administrator can petition the court to distribute remaining assets to designated beneficiaries. This step typically requires providing detailed documentation of financial transactions conducted on behalf of the estate throughout the probate process. The Tennessee probate process isn't swift. Crafting a detailed inventory, obtaining appraisals, and maintaining meticulous documentation takes time. Probate proceedings usually take 6 to 12 months and potentially longer if complications arise. I hope you found this information valuable. I'm Scott Hines, a real estate broker in beautiful Tennessee. My family and I have been assisting executors, administrators, and trustees with properties in probate for many years. If you find yourself facing the Tennessee probate process, remember, we're here to help simplify your journey. Our company is a family-based Christian organization with 3 generations of realtor expertise. Our approach is to combine the highest level of both probate expertise and real estate experience in a caring and compassionate manner. If you found this information helpful, please like, subscribe, and watch the next video in the series. Please also feel free to download my book, which is a guide to selling Tennessee homes in probate, with the link provided below. Thank you.